Assalamualaikum warahmatullahi wabarakatuh.
I'm SYAHIDAH binti Abdul Rahman.
I am NURUL binti MISWAN.
My name is MOHD KHALID.
My name is MUSFIRAH binti MOHAMAD RADZI, and this is our case law assignment. 1.0 Summary of the law case. 2.0 Parties involved in this case. 3.0 The right and duty of related parties. 4.0 The issue and the problem that has been raised. 5.0 The element of contract that involved in case. 6.0 The solution of case.
First, summary of the law case. Some contracts thought intended to be legally binding are provoked to be enforced. On another way, the court is faced with alternative construction of the agreement advanced by the parties, but is unable to decide which or either it is correct. In this circumstance, it is better to hold that no contract has come into existence rather than risk imposing an obligation on the parties to which they never accept.
Therefore, the terms of the contract cannot be vague but must be certain. As provided in Section 30 of the Contract Act, a contract which is uncertain or is not capable of being made certain is a void. So, in case KARUPPAN CHETTY vs. THIAN 1916 is looking for an available house for a rent, the contract was declared void for uncertainty because the agreement was not clear, as the duration of the lease is not specified or capable of being made certain. The court held that the requirement of certainty had not been, as the duration of one of the most important terms of the lease was undefined and uncertain.
Parties that involved in the case KARUPPAN CHETTY vs. THIAN 1960 is KARUPPAN CHETTY act as the plaintiff, which owner of the rental house, and the SUAH THIAN as the defendant, which tenant of the house.
Next, the right and duty of related parties. Each parties have their own right and duty towards the contract. KARUPPAN CHETTY has the right which the defendant does not state how long that he will stay in the house. The duty for SUAH THIAN is he need to state that how long did he want to rent the house, because in this contract time is matter and need to specify, such as only for 8 months, 3 years, and so on, for there to be a binding contract.
The important issue here was the language used may be to vote, in which case the court is likely to hold that there is no concluded agreement. For example, the contract is void for uncertainty. Same goes to this case. The language used are to vote and too general without any specification. Both parties agreed to lease at $35 per month as long as he likes. As long as he likes shows that there is uncertainty in the agreement.
There is several elements of contract involved in a case. In this KARUPPAN CHETTY and SUAH THIAN case, the element of contract that involves is certainty. Generally, under common law, there are two aspects to the issue of uncertainty. First is a language. The language used are too vague and not too clear, and second is failure to reach agreement on a vital or fundamental of an agreement or fail in completeness. there is no binding contract where the language used is too obscure and incapable of any precise or definite meaning that the court is unable to attribute to the parties any particular constructional intention. From here, we could understand that uncertainty will arise if there is uncertainty in the contract or uncertainty regarding the language and the meaning of the term of the contract.
Last but not least, the Malaysian law under Section 13 of Contract Act 1915 provide that agreement the meaning of which is not certain or capable of being made certain are void. The solution of the case. Certainty is the element of contract that should include to make sure that contract is valid. Because of the case have the uncertainty is the contract, the courts held that the requirement of certainty is not satisfied as the duration of one of the most important terms of this agreement was uncertainty. Therefore, the agreement is held to be void.